Good morning.
Good morning.
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 Well, welcome to a virtual oral argument session of the 5th DCA. I'm joined today by the youngest of the senior judges, Judge Orfinger and Judge Nardella. We have one case set for Zoom today. That's case number 21-2549. It's Patient Care versus Integron Preferred Insurance Company. Just as a reminder, we are being recorded and on YouTube and also streamed live. Mr. Nation, I will reserve 5 minutes for your rebuttal unless I hear from you otherwise.
That's perfect.
Okay, and with that, you may proceed.
All right. Thank you and good morning, everybody. I don't think I'm going to take the entire time. I certainly welcome questions. I'll start with this. We made 3 arguments in our initial brief. One was the divisible contract analysis. The other is a definition of due to. Spent considerable time on both those. And the third is the factual question arising out of whether or not there were visible signs of damage. I'll make most of my arguments going to be on 1 and 2. As to the divisible analysis here, we have an automobile policy that separately grants coverage for theft under the comprehensive coverage, separate premium, separate deductible, and then we have coverage separately for collision. And those two and they have a separate premium and separate deductible. And those two are mutually exclusive of each other by definition. The defense or the appellee did not address this divisible argument at all. And yet we have 2 5th DCA cases right on point and a Florida Supreme Court case right on point. First one is 1991, Bryant versus Allstate, where this court said that where you had claim for damage to the car under the policy and and I'll just read from the opinion. Those are, they have the legal effect of separate policies against one of the grouped risks. Here we have a risk of comprehensive theft and a risk of collision.
Mr. Nation, let me ask you, let's assume for the sake of discussion that we agree with you that these are separate and divisible coverages.
Yes, sir.
The issue to me seems to be the scope of the exclusion, where it says we will not pay for loss due to theft, larceny, etc., without signs of forced entry. So my question is to you is, I don't see any limiting language in that exclusion as to why it would only apply to one of the divisible coverages versus the other. How do you get around the breadth of the exclusion?
Yes, sir. First, I would, and I'll get that's argument number 2, but to get to your question, as this court has said, those are 2 separate policies. So you got this policy, you have a separate policy, one policy for comprehensive, one policy for collision. The appellee ignored that, completely ignored it, but they are divisible. You cannot use an exclusion in one policy to exclude coverage in a different policy. That's the legal effect of the divisibility. And here the exclusion is limited to the comprehensive coverage. There is no exclusion applicable under the collision coverage. They've completely ignored that. And I think the reason is they can't get around it. There's no way to get around it. And you're not able
what language in the exclusion limits it to the comprehensive, as opposed to, why don't you read it the other way and say it's limited to the collision, as opposed to it's limited to everything?
Because it only applies to the theft coverage due to theft or due to vandalism, all those things that are other than collision. And that's how the collision policy is defined, as collision. And then the theft portion is the comprehensive, which is other than collision. You've got a separately stated premium for the comprehensive and the collision. And if they are divisible, and as if this court said, the legal effect of separate is that you have separate policies for each.
Wasn't this theft an ongoing, I mean, the accident occurred, as I understand it, about a month after the initial theft of the car.
Yes, sir.
But wasn't this an ongoing theft? I mean, didn't the theft keep going for the whole month? It wasn't just the minute the car was stolen. It was a stolen car for a month.
You're correct. It was stolen the whole time. And that's why we look at in argument number 2. And I hope I'm clear that and say it one last time. You can't use the exclusion in the comprehensive coverage to exclude coverage in the collision coverage.
Wasn't Bryant, sorry to interrupt, wasn't Bryant and State Farm talking about separate causes of action? What language from those cases do you think supports best your argument that rather than it be separate coverage provisions that provide separate causes of actions, we should treat it as 2 divisible policies that aren't read as a whole?
Yes. And so in that case, the specific issue, you are correct, Judge Sasso, and that was there a splitting of the cause of action? In order to address that, the 5th DCA said, these are 2 separate policies. The policy for the coverage for the damage to the car and the even though contained in the same policy, are 2 separate policies. Here, the wrongful act of which Bryant brought the instant case is Allstate's alleged breach of the uninsured motorist provision of her contract, not the tort. The coverage is separate and divisible from the other risks underwritten by Allstate in the policy. And if we jump forward to the Yankee, Y-E-N-K-E, State Farm versus Yankee case, the precise issue in that case was divisibility, and it was divisibility of UIM from UM. And this court said in that circumstance, even though they're UIM and UM, those are divisible contracts. And here's what it said. The fact that the underinsured motorist coverage and uninsured coverage are contained in the same paragraph of the incident policy does not change the fact that such claims involve separate and distinct coverage issues, and therefore they found that in that case it was divisible. Supreme Court found
I guess that is what I'm getting at, though. Separate, distinct coverage issues, but still the same policy that should be read as a whole.
No, they should. You can't read the policy in the whole. If we go as a whole, if we go back to Bryant and read the footnote 1, where a policy grouping several risks incident to ownership and operation of motor vehicles, such as, and they list out the various coverages you get under your car insurance. The legal effect is no different from the legal effect of separate policies against each one of the group risks. And then if we go to the floor, and that was going chronologically, then we go to the Florida Supreme Court case, Flores versus Allstate. And the issue was, do we have separate and distinct coverages for PIP and Both those are injuries to the insured. And in that case, they also found separate and distinct policies. And so and we can't use the coverages or the exclusion in one for the other. We'd be ignoring that critical concept. But I want to get to argument number 2, and that is due to. So what does due to mean? If we go in a hierarchy, had their exclusion said, we will not pay for any loss arising out of theft, that's a very broad exclusion, but it doesn't say that. They do say arising out of 45 times in this policy. In all the cases, not just from your DCA, but throughout Florida, say that is the broadest type of exclusion. Or if it's lead into a coverage, it'd be broadest type of coverage. But this one doesn't. It says due to. And so the only case that we have in the 5th dealing with due to is State Farm versus Campbell. And in that one, Judge Cohen said that when you were positioning somebody to take an x-ray, have an x-ray, and dealing with this due to language, positioning the foot to get an x-ray is integral. 5th, define due to as integral, an integral component. Here, the theft is not an integral component.
Is that a rule? I mean, I think when you look at it broadly across Florida law, shouldn't we conclude that due to is equated with proximate cause?
Well, that's what Intigon here is equated it to is arising out of. And words matter, and they use arising out of 45 times in this policy. They use due to very few times. And so we know there is a distinction between those. And although we don't have any Florida cases on this precise issue, I cited 3 out-of-state cases. The most relevant would be Williams versus Intigon, where this exact issue came up.
Let me ask you about the Williams case, though. I mean, it seems to me that that case is somewhat distinguishable in that it dealt with a motion to dismiss. And this is a summary judgment. So obviously, I don't need to tell you, because you know as well as I do what the different standards are. So isn't that case a really no moment to us, since it dealt with a motion to dismiss and whether it stated a cause of action or not?
No, because in both circumstances, whether it was a motion to dismiss, there you're going to take the facts in the light most favorable to the pleader, plaintiff, the insured. And here we have summary judgment, where you're going to have to assume that there are no dispute as to facts. And so what is the common denominator in both those situations? What is the legal definition of due to? Because that was the issue. What is that definition of due to? Because if in our case, if the accident is due to collision, it doesn't matter, or due to the theft, then it doesn't matter whether it was a motion to dismiss or motion for summary judgment. But that due to language, and here's American Indemnity, Utica versus American Indemnity, page 19 of our brief. Same language. And there they said, assuming the theft exclusion applies as defendant argues. In other words, in that case, just like ours, assuming there was no sign of forced entry. That would only eliminate coverage for losses caused by theft. The coverage for vandalism, and here vandalism and theft are both in the comprehensive cover comprehensive coverage. But coverage for vandalism, the vandalism here, but for the coverage for vandalism remains. To defeat coverage, defendant would have to show through undisputed evidence that the loss was not caused by vandalism. Here, they have to show that the loss was not caused by collision. And collisions and thefts are not interdependent. Sure, but for maybe it's there. That's arising out of. Here it's got to be due to theft. Due to, and you've got to read the exclusions narrowly for the benefit of the insured. And so that due to has to be read narrowly. We know it doesn't mean arising out of, because they say that 45 times in other sections of the policy. And so what does due to mean? It means it has to be a closer connection. And the Campbell case tells us, in that case, positioning the foot was integral to the treatment, the x-ray, and therefore positioning the foot was due to rendering medical services.
So when you say integral and closer in time, are you saying that the last occurring event was the cause, or what is the rule that we would be applying if we're writing this up? What does the rule look like?
So here we do have almost a month gap, but I don't want to hang it only on that, because what is important here is the language due to. And so the rule would be that here they cannot show that the loss was due to the theft when it was actually caused by, which is broader language, caused by collision. And I would say if the court could just follow the rule that as it's written in the Utica versus Texas versus American Indemnity case, or even Maxey versus Universal in Louisiana, where they have the same thing. In that case, they said the loss due to theft does not apply to a subsequent fire loss because it was caused by fire. And there is a causal link. In your Campbell case, there was a direct link between positioning the foot and the x-ray, and therefore the court found that it was due to. And here it's not. They have a limiting language And the distinction, if I was writing the opinion, if I could be so bold, the distinction would be there's a hierarchy of lead-ins for exclusions, all of which need to be read narrowly. Arising out of, then in that case, I could see that a loss here would arise out of the theft if it wasn't a divisible contract. Since it is, that isn't going to matter. But if it's all one issue, it arising out of, yes, but due to is on our hierarchy lower than that. It's lower than caused by. You've got to have this direct, integral connection, positioning the foot to the x-ray, not a theft, and 25 or 26 days later, somebody collides. Those, although occurred in sequence, they are not causally related. Again, if it was arising out of, that would be different, ignoring the divisible contract component. And then the final issue, unless there are other questions.
Yes, you're just into your rebuttal, but feel free.
Just the final thing is there is a factual issue as to whether there are visible signs of entry, but I don't think we get there because I think it's a matter of law. If this court were to reverse and say due to is a tighter causal connection than arising out of, which is exactly what Integon's done here and what the trial court did, then as a matter of law, this loss is not due to theft. It is caused by collision and therefore would be covered. All right. Thank you very much.
Thank you, Mr. Nation. Mr. Middlemark.
Thank you, Your Honor. May it please the court. Mike Middlemark on behalf of Integon. I believe Judge Orfinger hit all the Integon issues nails on the head. I don't think there's any facts that are in dispute in this case. We have a theft. We have the insured admitting that she left the keys in the car. And 25 days later, the vehicle is found in a hit and run accident, and it is taken to a towing yard where Integon sends out its field representative who documents that there was no visible signs of forced entry.
Mr. Middlemark, let's talk a little bit about Mr. Nation's argument that the due to language defeats your argument because due to and arising out of are different. What's your best argument in opposition to Mr. Nation on that point?
Okay, so the best argument is the exclusion language, which states if any exclusion applies, coverage will not be provided for an accident or loss that otherwise would be covered. Accident defined as sudden, unexpected, and unintended event. And that's exactly what happened in this case. We have coverage under the comprehensive portion of the policy, and we have coverage, as Mr. Nation alluded to, under collision. Okay, let's assume that there are separate and distinct coverages. We know that the theft exclusion applies to comprehensive because there were no visible signs of forced entry. It's uncontradicted in the record, and that's what Judge Egan relied on in finding that portion, the comprehensive portion. And same thing for collision. This was an exclusion that applies because there was a theft and there was 25 days that took place and the theft never ended. And the only case that I could find, which was cited in my brief, was Bowling versus Northern Insurance Company. It's from 1938. But there, the facts are similar in that there was a theft. The police found the vehicle, and on the way to the police station, the police officer got into an accident. And the court concluded that until the vehicle was brought back to the police station, the theft was still ongoing, and said, we deem that the theft had not ended at the time the collision occurred. And that's what we have here. So if we have a theft that hasn't ended, the theft exclusion number 19 in the policy applies. There was no visible signs of forced entry. And that's why it doesn't matter if Mr. Nation wants to argue due to is more
It
limited.
does matter though, right? Because the exclusion incorporates that language. The exclusion says loss due to theft where there's no visible signs of forced entry. So we have to first conclude that it is a loss due to theft in order for the exclusion to apply, correct?
Correct. And that's what I'm trying to say. The
So
theft
back
never
to
ended.
Judge Orfinger's question then, and putting aside the case, just looking at due to, how do you define due to as opposed to arising out of? And what is the basis for your argument for the definition of due to?
Due to is because of, is the tantamount to proximate cause. There was no way that this collision happens without the theft, and the theft never ended. And so I could not find any cases on point in Florida or around the country. So what is proximate cause? We all know what proximate cause is.
Do you have any cases just for that limited proposition that due to is equal to proximate cause?
I don't. If I had, I would have certainly have cited them.
Counsel, in the property damage context, we have a case called SIBO versus American Home Assurance Company, which rejects the efficient proximate cause test and instead applies the concurrent cause doctrine. Does that inform our analysis here? And if not, why not?
No, because that was a property damage case, and that had it's got no bearing on an automobile policy where you have separate coverages for comprehensive and a collision. We acknowledge that the insured paid the premiums for both, and we would acknowledge that there was damage to the vehicle as found by the field representative. But the fact remains that this case, the cause of loss was reported as due to theft, larceny, or conversion. And the SIBO case had to do with a hurricane and whether the damages were due to a hurricane or some no peril created cause, which is what the insurance company was taking the position. And the court in the SIBO case said, look, you can do whatever. It can be both. But here, it's all arising out of the theft. The insured never took control of this vehicle prior to the collision. And I just go back to the Bolin case, the theft never ended. So there really is nothing to add other than, as Judge Orfinger noted, the Williams case, it was a motion to dismiss case. The car was recovered the next day and no claim for collision related losses were made. There were concurrent claims for theft and vandalism. The insurance company took the position on their motion to dismiss that, look, you left the keys in the car and that's why there was no signs of visible entry. But the court noted that the insured also made a claim for vandalism, which is a separate coverage. And that can't be determined on a motion to dismiss. And we don't know what happened on the motion for summary judgment. So that's why the Williams case has no place in this argument. And then he's claiming the Maxey case may apply, but there you had this theft and a fire on the same day, but the claim was made on the comprehensive portion of the policy, not the collision part of the policy. So the fact that the insured made a claim for fire and that was covered has nothing to do with what we have here. All the cases on causation in this particular case, as I cited in my brief, and the arguments I cited in my brief, they all have to do with the fact that this theft never ended. And that's what Judge Egan relied on. And that's why he found that the exclusion for theft where there was no visible signs of forced entry applied to the comprehensive portion of the policy, as well as the collision portion of the policy. And if there's no more questions, I just will rely on the cases in my brief talking about what a visible sign of forced entry is. In this case, Antigon submitted the affidavit of its field representative, the deposition testimony of the claim representative, as well as, the claim supervisor, as well as his affidavit, and the deposition of the insured. And so if you want to pick at the wings of a fly and say that there's one photograph that may show a handle that somehow reflected that there was damage, I mean, that's not enough. That's why I cited the Offutt case. Again, it's an out-of-state Maryland case, but they said only visible sign of forced entry was the lock or the keyhole found in a horizontal unlocked position. That's a sign more consistent with oversight than forced entry, and the policy did not insure against surreptitious entry or oversight. And that's what Antigon's policy says. There was no visible signs of forced entry. And the only thing that, not the only thing Antigon relies on, is the insured's deposition testimony, where she said she left the keys in the car. So when you got keys in the car, the vehicle stolen, you send out a field representative, and he finds no visible signs of forced entry as detailed in his affidavit. That's why there is no signs of forced entry that Judge Egan was able to properly rely on to grant summary judgment. And the last case that I cited was the Abrams versus National Fire case. And that, again, it's an out-of-state. The handle position may have indicated an entry, but the court was not required to find that to be a mark or sign of forcible entry. So the handle may have been a sign of an entry, but it wasn't a sign of a forced entry, which is what appellant needed to be able to withstand the motion for summary judgment. So based on all of those positions, that this accident, the collision, whatever, it was all due to the theft which never ended. That's why Antigon properly got summary judgment, and we would request that the court affirm.
Thank you, Mr. Middlemark. Mr. Nation, you have about 4.5 minutes.
I'll be very quick. SIBO does apply. It's not limited to the context of property insurance. It's how we interpret insurance policies in Florida. And if there's no anti-concurring cause clause at the lead in to the exclusion, then if it can be, if there's a combination of causes, one of which is covered, one of which is excluded under SIBO, the loss is covered. And here there is no anti-concurring cause language. As to the definition of arising out of, as Judge Porfinger asked at the beginning, or I'm sorry, due to, asked at the beginning, counsel concluded his statement regarding that definition by saying that the collision arose out of the theft. I think I wrote it down a couple times, arose out, and that is not the test. They knew how to say that if that's what they intended to do, and they did not. And so there are cases that define due to. We've got Campbell, and I'll just read this in Campbell, positioning the foot was triggered the exclusion because it was an x-ray, and that came under due to, and here's the definition applied by this court, Judge Cohen. These actions were clearly, and they're talking about cases that the losing party had used to try to distinguish the due to issue. And here's what Judge Cohen wrote. These actions were clearly not integral or causally related to the treatment to the patient. In stark contrast, positioning Campbell's foot was integral to taking the x-ray because without proper positioning, an x-ray could not be taken. Contrast that here. Can you have a collision without a theft? Well, of course you can. And then we have the out-of-state cases that specifically define due to, with our Texas versus American Indemnity, Williams versus Antigon. And I don't believe there's a distinction between motion to dismiss and motion for summary judgment when on both there's no dispute of facts, and the sole issue is what's the definition of due to. And then the Maxey case. As to the bowling case, the bowling case is a New York case which uses a reasonable expectation test. We reject that test in Florida, but more importantly, they were interpreting coverage, which has to be interpreted broadly, not an exclusion, which has to be interpreted narrowly. And then the final thing I have is I want to point out, because the first argument, this divisibility argument, I'm looking at Flores, which is our Florida Supreme Court case. And in it, it talks about this issue. While there is a diversity of judicial opinion as to the divisibility of policies of insurance, the doctrine seems to be that in the absence of misrepresentation or fraud, where a fire insurance policy covers different classes of property, each of which is separately valued and is insured for a distinct amount, the contract is severable. Goes on and then cites another case, Coverly, in this Florida Supreme Court case. It says, where property covered by a policy of insurance consists of different kinds of property, such as realty and personalty. And I'll get to that distinction in a moment. The different articles of property are separate valued. Here we have that, and are insured for separate amounts. The contract is divisible. And it goes on. And so here we do have divisible contracts. We can't ignore it. And then we look at the 50 CA's case in Bryant and also in Yankee. And Yankee is very helpful because it's UIM and UM in the same paragraph. Those are distinct. And I understand it there. It's talking about coverages, but they also make clear that the breach of one is not the breach of another. I get that that's not directly on point, but Bryant, it's instructive, but Bryant and Flores are. And with that, with no questions, I don't have anything else.
All right. Well, thank you both for your argument today. We'll be in recess till our next OA, which is in person.
All right. Thank you all.
Thank you.